Okay, thank you, Iffah. Okay, boleh start, Madam? Alright. So for today's agenda, we have 4 particular things that we would like to look at. Firstly, introduction to mooting. Mesti like Iffah dah explain a bit, but of course you guys nak tahu apa itu mooting. And then secondly is the court etiquette, whereby we'll be covering 2 particular things, which is firstly the language, ataupun dipanggil court lingo. And the second thing is court attire, which is I'm pretty sure you guys dah tahu pun, sebab it's very similar to what you wear during Hari Rabu kan. Okay, and thirdly, we will be covering mooting structure. But bear in mind, the mooting structure I'm about to tell you is actually the structure that you use in competitions. So not necessarily what you guys will be doing during your assignments lah. But it's important for you guys to be exposed to this and to be aware of how things work. And lastly, we'll be giving some tips, some from me, some from Iffah, and maybe from Manu as well. Okay, jom. So introduction to mooting. Mooting is basically, if you were to like write a sentence, is a mock legal hearing where participant, which is yourself, to analyze a problem. That's number 1. Secondly, research the relevant law. That's number 2. And then thirdly, prepare written submissions. And lastly, to present oral argument in front of judges ataupun a panel of judges. Meaning to say, certain court ada 1 judge, some court have 3 or more judges. So you can consider that as well. Okay, next. And then, interestingly enough, actually, kalau dalam mooting ni, are you guys familiar with the what you call the legal system of how kita ada High Court and then Court of Appeal? So mooting memang always often, I think like the mooting structure in all competition is at the appellate stage. Maksudnya kita takkan mula dekat High Court, kita akan dekat appellate court. There's a reason for that because
siapa tahu? Siapa nak bagi guess why?
I think it's a bit, kalau you guys just nak, give any views boleh je, but if tak, it's okay. Anyone? No idea. Alright, okay, it's okay, alright. So the reason being is because when you read a moot problem, usually there will be a decision by the High Court. You need to say, okay, High Court decided in favour of plaintiff, for example. And then there will be grounds of appeal. So bila kita masuk appellate court, kita akan argue on these grounds of appeal. Faham ke? Usually akan ada 4, 3, 2, something like that lah kan. So anything to add, Iffah?
So sebenarnya, because at the first stage kan, at the preliminary stage when you initiate a case, there's actually a lengthy procedure that you have to go through first, which is submission of evidence and all that, but you don't do that in moots. Moots you do submissions only. So that's why usually it's during the appellate stage where there's already a decision and what you're trying to argue is that decision is wrong, for example. Okay, so that's why it's normally at the appellate stage.
Okay, and then as you should know as well, kalau kita kat High Court, we call the parties as what? It's on the screen. Okay, plaintiff and defendant. Tapi kalau kita naik Court of Appeal atau Federal Court, we call the parties as? Exactly, that's correct. So we have to be aware of these technical terms. It's appellant and respondent and not plaintiff and defendant. Tapi bear in mind, like I said, ni untuk the real deal nanti lah. And also like if I said, we don't do the lengthy process of the trial stage. So the trial stage ni, kalau you guys read at the very bottom, the sentence there, is actually a mock trial. Mock trial ni pun later you guys will be, you guys buat ke kat Dengkil, mock trial? No, okay, tak. But basically mock trial is essentially a simulation as well, but it's the process from the very beginning until the very end, whereby you akan call up your witnesses, you akan tanya witnesses. Tapi mooting tak ada. Mooting is basically just submission in front of the judge. So it's different than mock trial because that is done at the trial stage. Okay, next. By the way, kalau you guys have any question, just raise your hand. It's okay to ask. We don't mind that. Okay, so secondly, court etiquette. The language that you guys use in court is very, very, very formal. Itu satu benda yang you have to be aware of, and it's so different than debate. Sebab debate, you are basically, okay, like to put it bluntly, you're arguing with the other side. But this one, you are talking to a judge whose stature is like one of the most respected person in the country. So you guys have to be aware of that position. You have to converse with the judge, hence you must use the correct term. So for example, kalau kita nak refer to a male judge, we call him by my lord, as in like my lord, may I begin my submission. And then secondly, kalau you nak guna the word you don't call like, you can refer to this. You need to say your lordship can refer to page 14, paragraph 15, for example. So kena add the lord and lordship. And the same goes for the female judges, where you have to use my lady ataupun your ladyship. And also I included Yang Arif because actually, interestingly enough, some court and also some competition maybe, the judge prefer a gender neutral term. Yang Arif you can use for both male and female. And personally, myself and Luqman during our final year, we have the trial advocacy. Our lecturer prefer that term because it shows like, Yang Arif, someone that's very respectable. So that may be preferred. Okay, and then next, you can't say thank you my lord, thank you my lady. It's so like boleh katakan simple, but basically you must say much obliged my lord, for your opinion on this matter, something like that. And then you can't say sorry, but instead you must say I beg your indulgence. So it's very high English in a way yang macam you need to speak like those from the ancient times, because that's how the court is like. Okay, and then next, you must refer to the counsel from the opposite team. So for example, you dalam appellant team, you refer those from the respondent team as your learned friends. Orang apa? Rakan terpelajar in Mdm, I guess. So learned friends is basically a sign of respect. So you don't call the lawyers from the other side as the lawyers for the respondent. No, you say the learned friends from the respondent, something like that. And then you refer to your teammates as co-counsel or junior counsel depending on your position. Kebiasaannya for us in UM, we use lead counsel and co-counsel. Kita orang tak guna senior and junior. But I guess in UiTM they use senior and junior counsel. So basically senior or lead counsel is the first one who goes during the mooting. So siapa yang cakap dulu tu, that will be the lead counsel. And then the second one will be the junior ataupun the co-counsel. Anything else that I should add, Iffah? Okay, alright. So are there any question up to this point? Tak ada. Alright, next. Okay, attire is actually quite simple. Kalau pakai black and white, macam dah settle dah. But you must be aware that you need to keep it a dark tone colour shirt. Maksudnya macam you can pakai either dark grey, navy ataupun black lah, simple. And inside must be white. You must also wear a tie.
And this attire? No, okay? I'm
No
just trying
jeans.
this because it's supposed to be casual lah. But just know that wear proper blouses, shirts, and proper blazer lah, and proper trousers or slacks. Okay.
Okay, so very simple je. Okay, next. Iffah next. Okay, this is the interesting part, the structure of mooting. But I tried to simplify it for you guys. Kalau ikutkan, let's go with the flow, ikut arrow. The first one, it consists of two teams, appellant and respondent, and two counsels. Oh, you must also refer yourself as counsel. You tak boleh refer yourself as the lawyers ataupun the person representing. It's just like very technical terms. So ada dua orang wakil appellant, dua orang wakil respondent. Tapi in competition usually you have maybe 3 to 4 people in a team. Cuma waktu submission tu je kena ada 2 orang. So faham Okay. And then the next one, the appellant will submit first. Meaning to say you have the lead counsel for the appellant, mungkin katakan 15 minit, and then you have the co-counsel. So meaning to say appellant habiskan dulu, baru respondent submit. Macam tu biasanya.
Lain dengan debate kan? Sebab kalau debate, Prime Minister and then leader of opposition and deputy. Tapi for mooting, appellant will go first and then the respondent will go after.
So tak ada ulang alik macam tu lah. You finish one side and then you go to the next side. Okay, so the fourth box, which is the appellant, will be given a chance to do a rebuttal. So rebuttal, I assume is quite prevalent in all competitions. Betul ke? Okay. Because rebuttal is given to the appellant, of course. Lepas respondent dah submit, you kena rebut apa yang dia submit kan? Pretty much similar to how, I guess, debating also. So you kena make sure yang your rebuttal tu is based on what the respondent has submitted. And then, the respondent will also be given a chance to do a rebuttal. That's also, you need to limit the scope of your rebuttal to what the appellant has rebutted. Faham ke? Dia macam ikut susunan. Okay ke? Boleh Alright.
Tapi untuk ni tak ada rebuttal kan? Ada. Macam ni lah. Dua minit.
rebuttal berapa minit? Siapa boleh jawab?
Tak. There's no fixed time.
Okay.
So satu senior junior, so yang ketiga terlibat. So rasa 5 minit juga.
Oh.
Tapi bila cakap dengan diorang, macam pakat-pakat lah. So that tahu dia nak buat siap-siap lah.
Boleh beritahu? Okay. So for you guys, Medin nak kata kalau nak ribat dengan seribata tu pakat-pakat lah. You know, discuss percent.
Sebab by right dia spontaneous.
Yes, by right you need to base your answers on what the other side has given. So tak boleh lah macam you nak tahu beforehand kan, usually in competitions. Yeah.
Just to give you guys like an insight. So basically, kalau in real life, when you do your preparations for mooting, you macam kena preempt what the other side is going to say, and that goes in your rebuttal. So contoh you dah list down, okay, you know the respondent might say all of this, and then during their speech you dengar betul-betul, and then okay, they did say what you preempted, so you can use that point against them in your rebuttals lah basically. Sebab for rebuttals in mooting, you don't have prep time. Like debate time, mungkin they will give you a few minutes for live speech, but not in mooting. You really have to prepare through. It's even worse when you have to do sir rebuttal, because for example, in real life competitions, usually rebuttal seminit, 2 minit. So after the rebuttals, terus sir rebuttals kan. So you only have that 1 minute, 2 minute to prepare lah your sir rebuttals. So memang you have to be quick to think, you know, on your feet lah basically. So just letting you guys know. And also in real life competitions, usually they will give, for example, okay, 30 minutes per side. So 30 minutes for appellant, 30 minutes for respondent. So it's up to however you want to divide that time. For example, if the lead counsel has more points, then you know probably it will be 7 minutes, 5 minutes, 2 minutes for rebuttal. Okay, I didn't do the math there, but like you know you get my point, right? So you know you can divide however you want. Tapi Mdm Fida dah explain tadi, for you guys punya assessment ni, teamwork matters. So bahagilah secara equal. Okay.
Kita rasa korang allocate 5 minit max.
Okay. 5
Okay.
minutes.
So you guys dah have the structure and dah diberi the time, so you guys don't have to worry about this, but just keep in mind lah. Okay. And also kalau you guys tengok the number 1 and number 2 kat atas tu, basically I just repeated the fact that each competition has its own rules and regulations. So macam contoh dari segi the amount of team members, the time given to each councils to submit. So semua benda tu akan ada dalam these rules and regulation. So you guys must read that first, of course, before you guys proceed with joining any competitions. Okay, and then some of the things that we should be aware of juga when it comes to the structure of mooting. Firstly, tak nampak lah kat screen. Okay, the first one is the lead counsel for the appellant will have to introduce the parties and all the counsel. So dalam mooting ni, I would say that the one that have the most responsibilities would be the lead counsel for the appellant. Sebab apa? Sebab waktu diorang nak ke depan submit, they will have to firstly greet the judge, they will have to introduce themselves, the co-counsel, lepas tu the counsel for the other team juga. So macam banyak benda nak kena cakap. It's just how things are. So you need to be aware of that. And then secondly, you will also have to provide a summary of facts kalau katakan judge tu minta. So there will be like something in your script saying that would your lordship would like to have some summary of the the brief facts of the case. So you guys can then be prepared lah dengan the script to provide this summary of facts. And then number 3, the time that each counsel have to submit is vary. This is what Iffah have said. So you guys kena pandai-pandai lah bahagikan ikut berapa banyak the lead counsel have to submit. Kalau katakan lagi banyak point for that particular lawyer, then he has to submit longer lah kan. Okay, and then number 4, judges will interject or interrupt to ask questions. And I think this is like the most unique part about mooting. You kena be prepared with questions being thrown at you. And sometimes question ni, kalau you tengah cakap dah habis pun, the judge will come in and interject and terus tanya about something else. And you have to be very spontaneous in the sense that you tahu apa yang you nak cakap dan apa you nak jawab. And never korang ignore the questions by saying that okay, I'll get back to it later or something like that. Kalau tak memang tolak markah you guys macam tu. It's very important to to answer the judge's question. If say you know the answer, then it's good. Kalau tak tahu pun, you need to have a certain style lah nak handle that situation. You tak boleh macam kata, oh, I'm sorry, my lord, I don't have the answers to this. But you must also like maybe say, I beg your indulgence, my lord. Would you allow me some time to actually look through my notes and something like that? Like, and buy yourself some time to check the answers. So it's very important to be on your feet. Okay. Number 5, the scope, or this is the thing that I said just now lah, kena be aware yang kalau nak rebut tu based on what the respondent dah submit, and then rebuttal tu on what the appellant has rebutted. And also, interestingly enough, I think for my particular competition that I joined, you can waive the right to rebut. Cuma in your case, janganlah sebab tu part of your assignment. So just keep that in mind. And then number 6, counsel can actually ask for an extension of time to the judge. So for example, kalau not in this one, you guys can't. Tapi kalau macam in real competition, you guys can actually ask, my lord, would...
I see that my time has left. Could I request for 2 minutes to continue my submission and wrap up?
Usually, you can't ask for that much time because you know you have already finished the time that was given. So 2 to 3 minutes is the maximum lah usually. Okay, and then number 7 ni pun is a bit technical and I guess it's not really important for you guys. Tapi memorials ni is another for written submission, right, in a way. So memorials ni, you kan tadi I kata like you have to prepare a written submissions. Written submissions tu yang you akan already submit in court kan. So memorials ni you will have to give to the opponent that you will be facing beforehand. So diorang boleh baca your memorials and diorang boleh tahu what's your point. So that's one of the very interesting aspects of mooting, sebab you boleh tahu point apa yang diorang nak raise dalam the oral submission. And from there, you can properly plan to actually maybe, you know, in rebuttal nanti. So yeah, it's very important to know that. Tapi tak ada memorial for you guys. Okay, tips and tricks ni is something that myself yang I tulis. Firstly, you need to know your bundle of documents and memorials inside out. You macam kena tahu, for example, the facts of the current case, and then you need to know the relevant provisions or statutes, and then you need to know the cases that you guys are using as precedents. So macam contoh, cases kan kita kena tahu kat mana where was the case heard. Is it in federal court, court of appeal, and high court? Sebab you know, if it's in the federal court, it has a larger what do you call, authority. Yes, the authority, the precedent would be a lot more stronger. And then
just to add, so the reason why you guys have to know like the facts especially and the authorities that you guys cite is because remember that the judge can intervene and ask you questions. So they will ask you about your authorities, like why are you citing this particular case, like why not another case, for example. So if you already know that this is the most superior or most authoritative case that you can cite, then you can answer the judge calmly and confidently that yes, this is the authority for our present case, this is the relevant authority. So yeah, just make sure you guys tahu lah. And for example, if you guys make an argument which you refer to the facts of the case, make sure you can bring the judge to the paragraph in the facts. So for example, you know, my lord, you can see this, my lord, this can be seen in paragraph 14 of the facts of the case, for example. So you cite an authority based on the facts of the case.
Okay, thank you, Iffah. So, like what Iffah said, you need to actually refer the judge to the particular page and the paragraph that you are referring to dalam bundle of documents. Sebab waktu submission tu, the judge akan ada that bundle of documents. Almost certain dia akan ada your bundle of documents. So if you can refer them to the particular point that you are making, that will very much benefit you because it just goes to show that you were, of course, planned. You are very much ready, and then of course any questions yang they give to you, you can answer. Next, you need to avoid a situation where you cannot answer the judge's question, and this is because it really affects your overall mark. It just goes to show that you were not prepared, and this is just my own personal opinion. So I think from there you need to be aware, macam Iffah said, what's the word? Preempt certain questions that would probably be asked to you guys. Sebagai contoh, mungkin like you know like, oh, this particular law, mungkin like the legal authority has certain things yang orang akan nafikan. So what you guys have to do is that you have to prepare exactly how to answer these kind of questions. So you macam like plan lah, you need to be proactive in looking through all your submissions and see mana yang you rasa oh ni kurang, and probably the judge will attack this point. So you need to have a prepared answer for that. So that's one tips that we could give you lah. And then you need to submit at a reasonable pace, because let's be honest, kalau you terlalu cepat, really no one will catch what you're going to submit. If you submit too slow, and then you will not be able to submit sampai habis lah kan, because you have to consider juga you were given like a certain amount of minutes. You need to make sure you dapat submit everything that you want to say. So just be in the middle, choose the right amount. Jangan terlalu cepat, jangan terlalu slow. Anything you want to add? Okay, alright. And then personally I think it's very important to incorporate your own style. Sebab sama macam debate, you guys have your own style, and I think mooting pun you guys can be unique. It's very important that walaupun mooting ni seems very formal, tapi if you guys can put in your personality, I think that helps, because judges like to see some, I would say, pizzazz macam tu lah. Sebab macam contoh, if you use a lot of emotion, you use lots of like style dari segi body language, the judge may find that very interesting and appealing. It's one aspect of advocacy yang not many people realise. Advocacy tu meaning to say submission in court lah. So macam kalau contoh you move around, you show like passion, that helps a lot, and I think that's also some very important tips lah. And then lastly, of course, you need to practice. I think more so than debate, mooting requires a lot more practice, because you need to understand your law that you would like to use. So practice tu macam like, I guess for many of us yang pernah try mooting, you will probably have to spend most of your nights looking into all your written submissions. You kena make sure yang macam you tahu nak jawab nanti. So macam practice tu, it comes naturally and you cannot run away from it lah.
And just to add, practice here means rehearse the script, your mooting script, in front of the mirror or with a friend. Sebab I think Mdm Fida explained tadi in the rubrics, eye contact, all of that matters, right? So you don't want to be looking at your script too much. So that's why this is where your practice will help you lah. Because if you practice it repeatedly, it's all in your muscle memory, So you tak payah nak tengok banyak kali pun. You are able to sort of like give out your speech naturally. Yeah.
Alright, so that's all the tips and tricks. Ada nak tambah lagi ke, Iffah? Manu? Tak ada Okay. So this is a quote yang I randomly found on the Google this morning. Saja nak tambah kan? Nak tambah. So words have power, words are power, and words could be your power also. And this person is actually the winner of a public speaking competition kalau you guys search. So essentially what I'm trying to say is that mooting requires you to use your words cautiously, effectively, and properly lah. So if you guys can actually implement the right use of words, that will very much assist you guys in winning the competition. So I think words is very important in mooting. Okay, and then I guess that's it from my presentation. Are there any questions?
Okay, I'm going to start. Okay, so this is me sort of representing the plaintiff of the case. Naqi will represent the defendant. May it please this honourable court, my name is Iffah Afrina, appearing together with my co-counsel, Mr. Muhammad Naqiuddin, representing the plaintiff, Mr. Faritz. The respondent, the Sukahati government, is represented by Ms. Amira and Mr. Ahmad. Before I begin, may I humbly inquire if your lordship requires a brief summary of the facts?
Yes, please.
My lord, this case concerns Sukahati government's concerning response to the COVID-19 pandemic and their administration of the vaccination for this deadly virus. While governments in other countries have proceeded and moved forward with their vaccination rollouts to their citizens, it cannot be said the same for Sukahati government. Instead, they have enacted the COVID-19 Vaccination Act 2001 that is discriminatory in nature, as it only subsidizes the vaccine cost for a specific group of people, namely high-risk patients and those with comorbidities, leaving the rest to fork out money to get a shot to protect themselves from the widespread virus. Therefore, my Lord, the plaintiff is standing before this court to urge for a declaration that this act, enacted by the defendant, the Sukahati government, is invalid on the grounds of morality. My Lord, we base our submissions on the naturalist school of thought. We submit that the COVID-19 Vaccines Act 2001 is invalid because it is not in accordance with the naturalist school of thought. My Lord, the naturalist school of thought views that all laws must be good. This is in line with the overlap thesis which this school of thought believes in. The overlap thesis asserts that there is a necessary relation between law and morality as they are inseparable in nature. In addition, we wish to cite Cicero, who pronounced that discriminative law is not law at all. We wish to emphasize that human law must conform to the contents of natural law. Thomas Aquinas has formulated an apt theory that expresses this, i.e., lex inesta non est lex, which yes, my Lord.
What's lex inesta less ex?
My Lord, lex inesta non est lex is a legal maxim that translates to mean that an unjust law is no law at all. And based on this theory, my Lord, any law which is against the concept of morality, that is unjust and immoral, is therefore not considered as law. Further, my Lord, Thomas Aquinas views that laws promulgated by human beings is valid only so far as its content conforms to the content of the natural law. As Aquinas has put it, and I quote in verbatim, every human law has just so much of the nature of law as is derived from the law of nature. But if in any point it deflects from the law of nature, it is no longer a law, but a perversion of law. Hence, based on the naturalist approach, the COVID-19 Vaccines Act 2021 is not valid as it deflects from natural law. This act is against the concept of morality as it is unjust and discriminative towards the other people who are not subsidized by the government. When the law is unjust, as according to Thomas Aquinas, it is not a valid law. And in order for it to be a valid law, it must be just and fair, and this vaccine should be made free for everyone, not just a certain group of people. Hence, in conclusion, my Lord, we submit that the law is invalid as it is not in accordance with the naturalist school of thought. If your Lordship has no further questions, that concludes my submissions.
May it please the Honourable Court. My Lord, as stated earlier, my name is Muhammad Naqiuddin, appearing together with my co-counsel, Iffah and Afrina, on behalf of the defendant, Sukahati government. My Lord, we have only one sole ground of submission in response to the plaintiffs, where we humbly submit that the COVID-19 Vaccine Act 2021 is indeed valid. My Lord, I suppose our learned friends on the plaintiff bench, we base our submissions on the positivist school of thoughts, which grant that the Sukahati government the right to enact the COVID-19 Vaccine Act 2021.
Counsel, can you explain more on positivist school of thought?
Yes, my Lord. Well, positivist believes in a separability thesis, which is not the same as the naturalist, and this thesis proposed that the validity of provisions of law does not depend on its conformity with moral principles. John Austin, one of the positivists that are well known in province of jurisprudence, states that the existence of law is one thing, its merit or demerit is another. Austin endorsed the view that it is not necessarily true that the legal validity of a norm depends on whether its content conforms to morality. There is no duty on the sovereign to make a law which are morally good or that promote the welfare of the people. In addition to that, according to Jeremy Bentham and John Stuart Mill, law must be regarded as separate from moral consideration in the sense that the law of the state is valid without paying regard to subjective consideration such as morality. Whereas in the case of PP against Jabbar, where we can clearly see that mercy is not the subject of legal rights. Based on the positivist approach, the act which provides free vaccines to high-risk patients is a valid law, as it is enacted by the Sukhahati government, which is the government in power. There is no duty of the Sukhahati government to make laws which are morally good as upheld by John Austin. Plus, separability thesis makes it possible to have a law that is not dependent on its conformity to moral principles. Even though the act is discriminative and not fair, where the citizen who are not high-risk patients have to pay 200 ringgits for the vaccine, mercy is however not the subject of legal rights, as illustrated in the case of PP against Jabbar. The COVID-19 Vaccine Act 2021 is valid without having to pay consideration on morality. Thus, the Sukhahati government has the right to enact the COVID-19 Vaccine Act 2021, as it is in accordance with positivist school of thought. In conclusion, my Lord, we submit that the law is valid as according to the positivist school of thought. If your Lordship has no further questions, that concludes my submission, and we humbly hope that the court rules in our favour. Much obliged.
Okay, so that's a brief demo on how a mooting submission works. But of course, as I said earlier, this is we prepared like literally few hours ago. But in real time mooting or in reality, a lot of hours training and preparation goes into preparing for a mooting speech. So if you are interested, you just want to see how it's like to actually do a proper moot submission, you guys can Google je, or go on YouTube. There are a lot of like mooting videos that you guys can watch. Kat Facebook pun ada. So just familiarize yourselves on how mooting is lah. So before we go and before we end, do you guys have any questions that you guys want to ask, or any reflections, any thoughts that you guys want to share? Yes. So rebuttals is basically, for you to reply to the opposition's case and to the respondent's case and say that, despite everything that they have said, please side with us because of what. So, okay, so for example, tadi kan, it's naturalist versus positivist. So in your rebuttals, you can basically explain or try to convince the judge why the naturalist school of thought prevails, why this is a better option compared to positivist school of law. So it's basically like a wrap up to show the judge that the judge should side with us. Does it answer your question? Yes. Okay. Any other questions? Okay, tips nak buat rebuttals. So as I said, memang korang kena preempt tau. What preempt means is when you guys do your research, when you guys write your script. So for example, you guys will write about the naturalist school of thought, why this means the law is invalid or the law is unjust. But you also have to consider the flip side. Why is the respondent saying that the law is valid? They're saying that the law is valid because they're the government. The government can do whatever they want. We elected them, So try to find the rationale behind everything and, use your logic thinking juga lah. Macam, why you disagree with that? Why, in any case, the government or the one who is in power must consider morality or must consider the needs of people on the ground, for example. So, just go a step further and cuba fikir, you as a citizen, what do you feel? Like, put yourself in, the plaintiff shoes. What would you feel? So yeah, those are like brief tips on what you can use to form your rebuttal. Remember that that's the last thing you say, so you want to leave an impact so that the judge sides with you. Okay? Okay, thank you.